So then the question becomes, this is the nature of my right. What prevents you from saying that this status right of mine cannot be violated by another person who's also claiming a right under 25(1)? Whatever be the nature of the right, we are two of us, both of us are claiming a status right under 25(1). They are claiming a status right. Why did Devaru come about? Because both were claiming a right to religion. Both. The denomination as well as the individual. So how to decide the question? That's why, my lord, the only way to decide the question. So I agree with all the three propositions. You need an essential practice test to resolve this tension. Without the test, what are they telling you to repress it? My bona fide belief. Who's going to sit in judgment over your bona fide belief? Please have it.
Madam, Devaru was not dealing with 25(1) versus 26. Devaru was dealing with 25(2)(b).
Yes.
A legislation,
Yes.
a social reform,
Yes.
versus 25(20).
Yes.
So
I stand corrected.
there is a very, very thin difference between the two.
Yes.
A social reform making an inroad into the freedoms,
Yes.
be it individual or be it collective,
Yes.
requires an interface which the courts would naturally decide
Yes.
with regard to proportionality and other tests as Devaru harmoniously construed.
Well, with respect, I agree.
And when it comes to a situation where it's not a question of the state making an intervention, but an individual asserting practice rights versus the collective asserting matters of religious affairs.
Yes.
In
But-
our understanding,
Yes.
26 by the plain reading of the Constitution prevails over 25 individuals.
But that is what Devaru does not accept, and I'll explain why. Because both are, I'm now on the question of what is the nature of the right claimed by both. Both are claiming in essence a right to religion. Am I right there? Both. So whether you're claiming it under 25(2)(b) or 25(1), it's the same thing. You're claiming a right to religion.
25(2)(b), madam, is claiming the state power to interfere in religion.
Yes, yes.
25(1) is claiming a individual right,
Yes.
which needs to acknowledge
Yes.
and tolerate the other individual rights
Yes, my lord.
of individuals. And there your point is very well taken, that one cannot be ignored in preference of the other. But what happens when that individual right is pitted against a group right?
I'll answer that. But first, let me give you the sequitur of what was just put to me. My lord put it to me that the state is claiming to make an inroad via a law. But the state is claiming it on whose behalf? On my behalf. The state is not claiming it on its own behalf. The state is executing the constitutional mandate. It's respecting, protecting, and it's obliged to protect my rights. The state is obliged, it's not protecting its own right. What are these entry laws? These entry laws are made for me. So they're acting in parents' patria capacity to protect the rights of individuals. And therefore, my lord, that distinction doesn't hold when it comes to deciding how to harmonize. So the only way to do it is to harmonize. Now, the other side is telling you, throw away the essential practice test, throw away Devaru, throw away Shururmat, make everything and everyone a denomination. I, Indira Jaising, can say I'm a denomination. Why not?
See, freedom of conscience was not given to us on January 26, 1950.
Yes.
That is something which man, civilization has, with the evolution of the spiritual aspect of man, through the passage of, you see, years and years and years, it is something which has been evolving. Constitutionally, it has been circumscribed by certain aspects. Now the question is, what has been evolved by man over the civilization? How much of that has to be protected? And at the same time, protection of that, how far it will sort of inroad into the other aspects which are the riders for that freedom. That is the whole essence of this debate.
It is true.
Now, it's not that we got a freedom of conscience only on 26th of January 1950.
Yes,
It has been there for ages.
yes.
So, but that freedom, how far constitutionally we have to curtail, that is the only aspect which has to be
That's
considered.
right. That's why I
Now,
said,
what has been developed over the ages, what has to be protected, cannot be taken away by the constitution.
yes.
That is the issue.
Therefore, that is why I said all the 6 questions can be collapsed into one. For a moment, forget the locus. This is the only question to be answered. All 6 questions lead you to this question. What is it that is protected? What is it that is not protected? That is the issue before these 6 questions. Now, will that question be decided on the basis of semantics, as has been suggested by the other side? Or is it going to be decided by the conscience of this court, by the conscience of the constitution, which some judges have called constitutional legitimacy and others have called constitutional morality? Forget words. How will you decide that question? You, as a constitutional court, also have a conscience. Your conscience is the Constitution of India. So this question will have to be decided with reference to the entire Constitution of India, not by looking only at words in 25 and 26. It's one indivisible constitution. How will you answer these questions? Just by looking at a dictionary and saying, this is how I answer. That is why I said in my written submissions, the first thing I've put down is how do you read a constitutional text? And there, even this court has referred to the proposition you read it as a living document. Forget constitutional morality. What is the meaning of living document? A living document, questions which the framers could not anticipate, you have to answer. And how will you answer questions which the framers did not anticipate? By looking at what? By looking at the constitution as an organic whole, you will answer that question. This question may not have been in the contemplation. All right, the question I'm raising, though I will tell you it was in the contemplation of the Legislative Assembly, whether women are untouchables within the meaning of 17. I will show you from the debates women are mentioned there. But whether you agree or disagree with that, it's not relevant to the outcome of this case. Article 17 is an additional argument. But the crux of it is this. Who to exclude, who to include? This is the question. How far will your conscience take you? Will it allow you to do a practice which excludes another person who has a right under this very constitution? Does it allow you to exclude a practice? That is why I said, okay, conscience is fine, my lord. Nobody, I'm not questioning their belief. Maybe a Naistik brahmachari may not be. I don't say it's not. I don't say it's not genuine. I don't say it is not bona fide. But I do say these are not the tests evolved by this court. This court evolved the test of essential practice. Because it is not a subjective test. That is why this test was evolved. Genuine is a subjective test. Are you going to sit in judgment over the genuineness? I don't sit in judgment over it. Are you going to sit in judgment over their bona fides? I don't. These are the 2 alternative tests which have been suggested. But this court said, no, to harmonize the rights, the test is essential religious practice. That is the answer to the question, how far to protect, how far not to protect. A practice. And therefore, please don't throw out of the window the essential practices test, because if you throw it out, then the autonomy argument will prevail.
Can also not ignore the civilizational and religious history of this land.
Yes.
While considering this issue.
Yes.
It is in that background that these 2 articles have come about.
It is true, but it is also
Living document, organic, it's good. But let us not forget the
background.
The past. The
Yes.
past makes the present.
Yes.
We can't
Yes.
ignore the past and say there was a vacuum and on a clean slate we started the constitution.
It is a clean
debate.
slate. According to me, it's a clean slate, but we can have a debate on that. We can have a debate on whether I take the view it is a clean slate, but I agree that the background to the drafting, may I just complete? I agree with you that the background to the drafting of 25 and 26 was the existing religions in India. It was. Whatever they may be. It was Hinduism, it was Islam, it was Christianity, it was Judaism, everything. That was the background. My Lord, everywhere in the world where I travel, I'm told, wherever I go, there's no other country in the world, no other constitution in the world which protects every religion. None. I challenge my friends on the other side to show me one constitution. Many constitutions have been cited in this court. Show me one constitution which protects all these religions, every religion. So that is background in which these two articles have been drafted. There's none, my Lord. I can tell you, international jurists have given opinions on this, that India's constitution is unique. That is why it's called unique. But this is the reason why it's called unique. Because it protects all faiths. And because it also gets rid of all the limitations on the right by rejecting caste, by allowing temple entry, by removing all the disabilities attached to religion. That's the reason why it's considered a unique constitution. No other reason. You think of the consequences of what they're saying. What was the case about? That another Brahman, except a god Saraswat Brahman, cannot enter that temple. That was the argument. You want to accept that argument? Their argument, what is the consequence? There'll be no temple I will be able to enter. It will be a complete balkanization of Hinduism. Torn to bits. Everyone will say I'm a denomination. Whereas the history that is being told to me is the history of this country is the unification of the different sectors, sects, call them what you like. Then there's a question which requires to be answered. In that case, why is 26 there? What exactly was the need for 26 in the Constitution of India? It did not have been there. Or you could have had, could you have, okay, let me reverse the question. Can you have only 26 without 25? Is it possible? It's not possible. Then comes the next question, what was the need for 26? That goes back again to the nature of religion in this country. That is the answer to that. Hinduism has been over centuries reforming itself. Religions reform internally. We are told no court should not reform religion. But the fact is that every religion reforms itself from within if it has to survive and if it has to have any meaning for human beings. And therefore, the history of Hinduism is the history of reform movements within Hinduism. That is why there is a need for denominational protection.
That is different from saying that the court should reform a religion.
It is very different. The court's only recognizing it. You are recognizing that process. Just as I was told that there's a background to these articles. Similarly, there's a background to putting denominations there. The background is the background of reform. Tell me one religion which has not reformed. Same with Islam. At least in law school, I studied Muslim law from Faizi. I studied Hindu law from Mullah. So you take any book on Muslim law and Hindu law, you will see a history of reform in it. Because religion has the capacity to regenerate itself, to reinvent itself. If it is going to be relevant to human beings, it is going to have to reform itself. And it has done. And that is why the word social reform is there in 25. Where is it? 25 2b. These three go together. Social welfare, social reform, and throwing open Hindu Hindu institutions, religious institutions of a public character. The three go together. Reform of religion is social reform. What else is it? Are you reforming the economy? Are you reforming finance? Are you reforming a secular matter? No, you're reforming religion. And what's his name? I think Mr. Dhawan is there. Yes, he said I'm an Arya Samaji. Yes, he is an Arya Samaji. He said it. He said it. But what he didn't tell you is that Arya Samaj does not believe in the sanctity of the Vedas. So there are changes. This is why a denomination must have a doctrinal change. There has to be something doctrinal in it to be a denomination. You can't say I'm a temple, so I'm a denomination.
Hey, madam, what is unique in India is diversity is our strength. And what section Article 26B does is to recognize the diversity. We are strong because we are diverse, and diversity is our strength. And to bring about a recognition of that diversity in denominations, Article 26B protects it. By giving such a protection, there is a unity also developed in the country. That is how we should look at it.
Yes, it is unity and integrity of the nation. Not only your doctrinal differences will be protected,
Therefore-
but your interreligious differences are also protected.
Therefore, respect diversity.
Yes, respect it, but show that you're diverse. Don't show me that I'm a temple and that therefore I'm diverse. Show me your diversity, no? I want to make one observation, and if I'm wrong, your lordships may correct me. In the 75-year history of this court, the only institutions that have got denominational status are mutts. No temple has been given denominational status. Surely there must be a reason for that. There are doctrinal differences. Therefore, the three-pronged test. An ideology that you follow, a theology that you follow. How does it change from the previous ideology? Then an organization. And then what's the third? Name. Name, as somebody pointed out, the word denomination itself includes norm. You show a doctrinal difference from the other religion, and all mutts which came to this court have been given denomination. Why? I am suggesting that two more. If you actually go through all the judgments, you will find two more tests which are not articulated in this way, in the way in which I'm articulating them. They have a living guru. Mutts. A temple doesn't need a living guru. But a mutt needs a living guru.
But temples are aligned to mutts.
Temples
They're all
are set up by mutts, but they are separate institutions. But every denomination claims to have a living guru.
Madam, what you are arguing is to read clause A with P. See, clause A of 26, 1A. Establish and manage religious institutions. B. Freedom to manage the affairs in the matter of religion.
Yes.
So do you mean to say that the denomination must have a religious institution in order to enjoy 26 rights?
Not only that, I'm going to go a step further and say, what about C and D rights? It's property. They have property. My lord, today every denomination in
Property, madam, that we read, or at least prime office I see, C and D independent of A and B. Because C and D is qualified with the words in as per law or in accordance with law.
No, not C. I'll get into that.
C reads into D. You cannot maintain property and administer property
Yes,
differently.
my lord.
They are
Yeah.
overlaps.
Yes.
So do we read these two, A and B together and C and D different?
Yes. It is true.
So-
But my question is, what
So
is the second?
definition, as you are saying, itself the constitution restricts the definition of denomination by positing the denomination or its section to an institution. Now that institution may be a mutt, maybe a temple.
Yes. Maybe is an open-ended question, but for the sake of argument, we may accept. We may accept it.
What is important
All right.
is
Okay.
the temporal existence
Yes,
of something which is an institution
yes,
in fact.
yes, in fact, in flesh and blood.
It may be a building, it may be a field, it may be anything, but then
Yes.
there must be a temporal existence
Yes.
in spatial terms.
That is the
In
three prongs.
space.
Yes,
What is occupying spatial space
yes,
terms?
yes, that is why Ramakrishna Mission was declared a denomination. It has a structure, it has an organization, it has a corporate personality, it has a name, and it has a doctrinal difference. All must exist.
But you see, Auroville was not. And
Yes,
that is
now-
where we need to examine Mittal, SP Mittal, in relation to Acharya Jagadish Guru and Ramakrishna Mission judgment.
Yes,
Because there has been a little bit of a difference of views
yes,
as to where we are identifying a denomination
yes,
or a section. We may read it by qualifying it with the institution. Maintain, so the denomination must come. It will establish and maintain an institution, and in that institution, the matters of religion are completely their exclusive domain.
in doctrinal matters,
State cannot make an entry, even in exercise of social reform. This is the way the review petitioners have
yes,
interpreted.
yes, even whichever way you interpret it. The question remains, when any practice of yours which is discriminatory, first of all, let us take the case of temples. Why? Because we are dealing with temple entry case. That's why I said I'm going to confine my submissions to the case of temple entry. It stands on a different footing from denominational rights. It's a standalone right. Even if there was no denomination, I would have the right to enter a temple.
Correct. 25(2) does not speak about the religious denomination at all.
Yes.
It mainly speaks about it's to be take care of two things, as you rightly said. One is the public, the social welfare and social order. That's one part. The second is with akin to the specifically referable to in the institution of public character. So long as these parameters are satisfied, we are not going to section 26 at all.
Yes.
Like you said, for a religious denomination, they have number of institutions. They will come under the purview of 25(2)(b), provided the institution which they are maintaining or managing or administering, they have a public character.
Number one,
As
public.
simple as that. So,
Yes.
yes.
And that they are religious, qualified by religious. That's where the doctrinal aspect comes in.
Religion is, see, when the state is expected to invoke 25(2)(b), it actually deals with the religious practice
Yes.
on the face of it. There's no dispute on this because that is not a case of 25(2)(a).
Yes, yes.
But both the state and then if on a judicial review by the court, we are concerned with only with the social welfare or the social order only. We are not. It will have an impact on the religious practice. It may have as rightly said, it may lead to the consequence of religious reform or religious belief. But we are concerned when you look at it, you look at the prism of social welfare,
Yes.
of the social order.
Yes.
To that extent, we agree. We follow you.
I could not have put it better. That is my
Yes.
submission. What do we mean by social reform? That is why I said social reform is reform of religion also. Otherwise, why you need it in that article? What for? Why is it in a chapter on religion?
One thing you must bear in mind, matters of religion in Article 26(b) is not restricted to essential religious practice.
Yes.
You can't give a restricted meaning to matters of religion.
What I- Therefore,
But at the same time, Article 25(2)(b) can operate. Both have to be harmonized at the end of the
yes,
day.
yes.
That is Devadu.
But
By restricting the expression matters of religion
to
to
essential.
essential religious practice only
Yes,
will
yes.
be causing damage to that expression.
So therefore, we need to understand why it was included, why it was imposed by this court. May I put it
Just
that
as only invention of this court
That is what, yes, but
That is
the
why they're
question,
saying don't,
no,
Go
they are
by
saying-
that test.
yes, I've understood them very clearly, and I must make it clear that even my friends on my side are also going to argue don't have it. I know that, but I insist on it, and I'm giving my reasons. Because,
What are you doing with your mobile? Keep it in your pocket.
I beg my,
Why are you recording? Keep it inside the pocket.
okay. So I want to explain the reason why. On a plain reading, this answer is correct. On a plain reading, it is all of religion, essential and non-essential. But how will you, as a court, resolve the question when both are claiming a religious right? That was the discussion I was having. Two people are claiming a religious right, and both of them are saying this is the sum total of religion of my rights. Essential or non-essential? How are you going to resolve that?
see, it is not a question of claiming here.
Yeah.
It is an enabling power for the state
Yes, it
to
is.
reform.
Yes, it is.
Now, when a piece of legislation is made by the parliament or the state legislature with regard to reform under Article 25(2)(b), the question is whether it is making an inroad into a matter of religion
Yes, and
or whether it is a matter where it is a reform per se.
yes, it is.
Now, there has to be some kind of a balance drawn. In that context, the submission is don't say only essential religious practice.
Then say what?
It is
How will you,
a matter-
what is the alternative test given to you?
may be a matter of religion, but in the name of social reform, a religion cannot be hollowed out. That was the submission made.
I'm trying to say two things. I'm saying in the name of religion itself, all right, this is the right time for me to give this answer.
As your colleagues are going to argue, as my sister put it, it can be the essential part of the religion can be looked at from both sides.
Yes,
It will also help you in a way,
yes,
in the sense,
yes,
if
because,
you remove essentiality
yes,
and keep only the social reform or social welfare, then it will give you more flexibility to the state to do it.
well, not yes, it is true. The outcome may be the same. Because you will harmonize with social reform. You can't get away from harmonizing.
25 does not say anything about essentiality.
Yes, the
But
question.
only thing is we are trying to put it to you. When we deals with it, court will have to be a little bit more circumspect when it deals with an essential, because it is not the practice that is concerned. It's a
Yes.
belief. See, when it encroaches upon the belief, the practice which encroaches upon the or you can't segregate it from the belief, then both the state and the court will have to be more careful and circumspect.
Yes, my lord.
Even assuming when they are access the power in 25(2)(b.
Yes, yes. My lord, as your lord put it to me, you will have the benefit of both arguments.
Yes.
You will hear the argument from one of my colleagues that you don't need the essential practice test at all. From our side, that means those who are supporting temple entry will also be arguing this. Why? Because the outcome may be the same. Whichever way you decide, the outcome will give me my right to enter. Okay, but the question is, you can't do away with the harmonization principle. That is it. Now the question is, what will you replace it with? With what will you replace the harmonization principle? You need a test to harmonize. Get rid of essential practice. It was put to me, social reform. If I can show you it's a bona fide social reform, you will accept it. You will accept it. All right, don't go by the essential religious test, go by the social reform test. It's fine. The outcome will be the same. Certain rights of mine will be protected. I'm here before you to say, protect my right. This denomination can't keep me out, or this religion can't keep me out. Today I'm dealing with the temple. Now, my lord, second criticism of the essential practice test is this, that a civil court or a constitutional court can't decide. My answer to that is, it is not a civil court or a constitutional court which is deciding essential and non-essential. All religions internally have that test. Every religion has that test internal to the religion. It is there. in every religion. One example of that is a judgment of this court in Saramanu. The question arose whether triple talaq is an essential religious practice. Now, how was the question decided? Not because the court thinks it's not essential. That religion thinks it's not essential. Let me be clear. I am not saying, all right, you decide what is essential. I am saying your own religion, even in Hinduism, there are dictates which are mandatory and there are those which are advisory. And every normative system of law makes this distinction. Justice Bakshi said that. He said, is there no distinction between void and voidability? Is there no distinction between mandatory and advisory? There is. In every system of law. It exists in Islam, it exists in Hinduism, it exists in the constitution, it exists everywhere. How many times your lordships have decided that this particular law is not mandatory? It is only advisory. So it is there. I don't want confusion on these issues. Whichever test you use, you use. But it is false to suggest that this court is deciding what is essential. No, that religion itself is deciding what is essential to me and what is not. And that test is being used for harmonization. Now, if you still want to get rid of the test, it's fine.
So, madam, to what extent do you want this essentiality to be gone into by the court? We're not very clear about that. You said you keep it, but then religion will decide. What ultimately is your crux of the argument? What do you want? You want the court to go into the religiosity or the essential religiosity of a thing? What is your stand on?
I am only saying this much. Theology is a matter of fact because it is written. For example, it's written in the Quran, in the Hadith, in the Vedas. Nobody's been able to date the Vedas so far. We don't know what is the date of the Vedas. In the Puranas, in the Agamas, it's all there. Right? So what is a matter of religion is a question of fact, is my argument. It's a civil right at the end of the day, raised to the level of a constitutional right by this constitution. It, as my lady put it to me, it always existed. It's inherent in being human. We all have that right. We didn't need a constitution to give it to us.
But it has been raised to a constitutional right, but then qualified also.
Yes.
Alan, what
So
is it according to you? You're not clear about that.
My lord, I agree. That question can only be answered case to case. I agreed that the limitations which are there in 25, I am bound by those limitations. I can't claim a right outside those limitations. I can't.
I'll give you a basic example. Suppose there's a religion. There are minorities inside religion also.
Yes, there are.
There are denomination and any other section. The constitution uses those words. Now, if the court gets into that, what is the parameter? Should I decide with the majority view of religion by oneself?
No.
Why do I get? How do I? Am I competent? Is the court competent? That was one of the questions, and we have to answer that. Who decides all that?
That's right.
We become theologians.
Your lordship used a very interesting word. Your lordship said minority. That word has not been used till today, till now in these proceedings. Minority. Minority within a religion. What happens to a minority within that? In a different form, the question has been raised by Justice Bakshi. Can two people dispute between themselves what is religion or not? That question has also been raised. So the minority, let us understand what is a minority. Within a doctrinal minority, it is a minority which has a difference of theology with the main religion. That's when it becomes a denomination of its own. What distinguishes a denomination from a non-denomination? What is it?
No, it is not so compartmentalized, madam. The difference may not be denominational. It can be only ritualistic. It doesn't make a denomination or theologically different. It doesn't. I have to perform something. I do it in a particular way. That doesn't mean that the theology is different.
That is ritualistic. Ritualistic is part of theology. Rituals are part of theology.
But that will not form the core of theology because ultimately...
No, that's where the essential difference and non-essential comes in. It doesn't form the core of theology, I agree.
Who decides that? Every time if the court intervenes, there is a limit. You are very correct, case-to-case basis. But then sometimes some minority have to be given, otherwise the whole protection of the constitution appears to be illusionary.
No, the answer to that is the religion itself decides. I've said it. I am not inviting you to become theologians, but I am inviting you to say, please have knowledge of what is the theology of this particular institution. Have that knowledge with you and then take your decision. What prevents you from getting that knowledge? Everything is available to you. What is not available? The Vedas are available, the Puranas are available, the Agamas are available.
When there's a difference, which prevails? Do we intervene in that?
No, that also the religion itself decides. It decides.
That is the contradiction in your argument.
That is where,
Decide you
that
say,
is
religion
where,
decides and then you say, no, you decide.
that is where, if such a dispute ever arose in British India, let me go back to British India. If such a dispute ever arose in British India, the judges used to call the theologians to the court and ask the theologians to give evidence about it. They did it. They did it because to discover religion is a question of fact. How do you discover what? How are you going to discover what is religion?
Finally, on a particular, probably you have to assist on that.
Another thing, Article 25(2)(b) does not create a right. No
does-
right is created in
It's an endowment of power.
It is only a conferment of state.
Yes, it's a power.
Now, when the state makes the legislation, if there is a challenge to that legislation, then the question would arise.
Yes, it
But-
will.
Under which right, which is the right which is being claimed under law?
Yes.
The right of entry is being claimed.
Yes, yes, the question will arise and you have to decide it.
Where is the right of entry?
The right of entry is in Article 25(1).
Let us say, for example, we'll give a stark example. Let us say the temples of Kashi. They say anybody south of India's, because everybody is referred to as south of India's. Anybody south of India's is not permitted entry into any temple in Kashi. Then can that not be curbed? Suppose the temples of Kashi say anybody south of India we are not permitting.
A Hindu.
Hindu temple.
Yes, and a Hindu trying to enter.
State will come up, either the parliament or the UP.
Yes, yes, yes,
State can make a law
yes.
that temple entry, it is open. This ban, such a denominational, what you call, suppose they had a religious congregation
yes.
and made this resolution. To get over that, the state will come up. But Article 25(2)(b) doesn't create a right in anybody with regard to temple
It
entry.
does not. It
Does
is an
not.
endowment of power. It is an endowment of power. I didn't say it's a right under 25(2)(b). I didn't say it. 25(2)(b) immunizes such a law if it is made.
Now, madam, then we again come back to the basic question. Basic question is lifting the wheel of your intent also. Suppose, would it be believed that you are a true believer, but you go to a place, you violate that? Is it the role of a true believer that I will go there, but I will violate the general predominant sentiments? I will do it in my way. Is it a belief? And then we'll have to maybe lift the veil of your intention also.
No,
Whether
that
it is
answer.
maintainable?
I will answer that.
What is behind that?
Madam Indira, I think our questions are also now enough to understand so that
Yes,
proceed further.
yes,
Just a bare idea. Probably 25(1) is your real hallmark.
yes,
Where you are conferring, you are
Yes.
seeking right.
yes. Not
Just-
right, I'm claiming a freedom.
Exactly. So, in terms of to understand whether 25(1) confers a fundamental right to enter let us give by simple example, to enter into a temple,
Yes,
or does it recognize a right to enter the temple, which was very much there as on 25th January 1950
yes.
or prior thereto?
That is why existing laws are saved.
If you are able to probably propound your theory that 25(1) confers an independent right to enter,
Yes,
then what you are saying probably.
yes, that is precisely what I'm saying.
But if 25(1) is only a recognition of a pre-existing right,
Yes,
then situation may be slightly different.
Yes.
So probably I think on that premise you can proceed.
Yes,
further.
Lord, I'll try to
But for
answer
that
question,
purpose,
but that is my
Also,
submission.
please keep in mind the language of 14, 15, 16,
Yes.
17
Yes.
and 25(1).
Yes, my lord. And is the question, that is my submission, that I get my freedom from 25(1). What are the limitations? Ones what are written there. In addition to that, a Hindu has a right to enter a Hindu temple, right? Hindu as defined by law. Okay, as defined by law. For the moment, I'm not getting into the question whether a non-Hindu can get in. Let me confine it to Hindus. And this, so now I want to address the question put to me about, can I interfere with the ceremonials inside the temple? That is where this court has drawn a line. So the line is not drawn at entry. The line is drawn at the stage of ritualistic performances. That is where they say you cannot do what the agamas don't allow you to do. The rituals, that is the answer that I will give, at least in relation to Hinduism. I can't go there and say, no, this is not the way to knees namaz, that is the way to offer namaz. I can't do that. Why? Because it's part of the ritualistic part of that religion. And this court has protected ritualistic practices. They have. In Devaru, they protected it. In Shururmat, they protected it. In every case till today, they have protected rituals. How to perform a puja? I can't go there and tell the pujari, perform it like this and not like that. That line has been drawn. That line has been drawn by this court. Then I can't say, oh, the pujari should not offer a coconut, but offer some flowers or whatever. These are ceremonial and ritualistic practices, which this court has put beyond the review of any law, beyond the mandate of any law. That's why the closest that this question arose in this court was in the two cases of appointing priests. That's the closest answer. You give me that, Anantya. Yeah, I'll read that. There are 3 judgments of this court which address that issue. And Adishaiva, Sheshamal, and there's a third one, Adintyan. These three together address the issue of protecting rituals and how to perform a puja. That is where they said that abolition of hereditary priesthood is constitutional, provided they have knowledge of the agamas. You can't touch that. No law of social reform can tell you how to change your agamas. So there is a protection. There is this residual protection. You call it residual, call it expansive, call it what you like. The point is, it has never been challenged. Okay? And I today don't intend to challenge it. It's an academic question for me. Tomorrow a woman can say, I want to be a priest. Possible. Question has never arisen. Even for the first time, the question has arisen in Sabrimala whether keeping a woman out is constitutionally valid. Until 2018, the question didn't arise. So what questions are going to arise for you in the future, I am not going to say. But I am going to tell you what this court has done. It has protected ritualistic ceremonies and said these are beyond social reform because they are the core of religion. So therefore, it is not my case that you can change those practices. I'm not arguing that today. Maybe people, I'll tell you a very interesting, it's a small story, 2 minutes just to lighten the atmosphere. One of the women lawyers came to meet me. She saw me very agitated all the time, wondering what I'm going to argue in court. I was confused after listening to 55 counsel on the other side. I lost my mind. So she came to meet me. This young lawyer, she's here in this court, practicing in this court. She said to me, Madam, why are you so worried? Never mind. Let them decide what they want to decide. Let them say that a woman can't enter. We are here, no, we are the younger generation, no. I'm giving you a promise. If this court decides that women can't enter, we are there to reopen the judgment. She said that to me. That's the day I decided, let me not get confused by what my opponents are saying. Let me not think what's going to happen after me.
Let us not open rituals and
Yes.
practices which have been there over centuries.
So,
Let this court not open such things.
with respect, I agree, because that is the law declared by this court so far. It has been protected. This court has protected those rituals. But the religion itself can reopen them. The church in England has allowed women to become priests.
So did that lady colleague of yours say that we'll flout the orders of this court?
No. They said that there is always the power of review and the power of curative and everything.
In the manner known to law.
Yes, in a manner known to law. In a manner known to law. So they said, all right, 9 judges we'll ask for, 11 we'll ask for, whatever. Well, I'll tell you something. It's again an aside, but a very important one. Answers the question of locus. It answers the question of locus. My lady has been saying, how can you reopen judgments? The history of this court, unfortunately, and I will say I agree with my lady Justice Nagaratna, that a binding judgment of this court cannot be collaterally attacked by an Article 32 petition. I agree. But it has been done. It has been done in cases which I have appeared in. And these are the cases they're relying on. By the way, what was the sheet anchor of their argument? TMA Pi. What was TMA Pi? It was an Article 32 petition to open Unni Krishnan. Reopen Unni Krishnan. I appeared in the Unni Krishnan matter, which said no capitation. They wanted to do away with no capitation, so they filed a petition under 32 and this court entertained it. So don't blame us for lack of judicial discipline.
We have to maintain discipline, that is important.
It's been happening.
Which is important.
It has happened in my cases. I was appearing in TMA Pi. I resisted it. I said, I argued Unni Krishnan. You show me why Unni Krishnan is per incurium. But an Article 32 petition, and that is the only case they're relying on. Now you know the reason why they're relying on it.
No, I'll draw an analogy. You said that every religion is open to reform. So this is by part of a reform. We change our views. So give us something.
All right, my lord.
Law is fluid. Law is also
Let me-
the Constitution is a living document.
My lord,
You
lawyers
also
will be
evolve.
happy. Lawyers will be very happy if you entertain 32 petitions. I
The
will
thing is
come and
that
fight.
this side, both sides should be clear in the mind, open in the mind. Intention should be very clear.
I will also come and file 32 petitions if you're willing to reopen settled judgments. Why not?
Not so casually. Not so casually.
My lord, I'm telling you, the only losers in this court are the ones who obey the law. We are the only losers because we don't file petitions in closed cases. I'm telling
You
you.
don't have to be so narrow. Law is only for the law abiders. As simple as.
Yes, but
So that doesn't matter. It's a fact. But then there has to be we have to live by the rule of law.
yes, law is for the law abiding, but where are the law abiding people in this country? I'm not talking about judges. I'm talking about this side of the bar. I'm talking about my worthy opponents. Why are you so angry with me? Gopal. Okay. Thank you. Thank you. Yeah. Because Mr. Subramaniam made the submission. He said 26(2) overrides. What does it mean? Tell us what it means. What can you do and what can you not do? You can't make half submissions in this court and get away with it, my lord. The logical sequitur will have to be drawn, or you withdraw your submission. He is at liberty to withdraw his submission. So my lord, that is why I said I need that. I deserve that prize now. That prize I take for Mr. Singhvi. Why is he not here? Mr.
But
Singhvi.
now you are on shaky ground. The way you are reacting, now you are on shaky ground for that award. What you did not do then, you are now doing it. You can confine your arguments
All right, my lord. Yes, that grave and sudden provocation has gone. So, my lord, the three judgments of this court which answer the question raised to me are Sheshamal, Adishaiva,
And
and this one, and Adyantan. All three dealt with this question, the extent to which you can interfere with what has been called the core of religion. And the two held that abolishing a hereditary principle does not amount to interfering with religion, so long as the person who comes in knows the agamas. And at least in the state of Tamil Nadu, well, Lord, I must tell you a small thing. I'm being assisted in this case, by, first of all, by an all-male team. And secondly, I don't know what to do because one of my AORs is called Parameshwaram. No, your amicus is Parameshwar. And my AOR is Padmanabham. And there was one more person who had a similar name. Anyway, these two are surrounding me. And my friend who is assisting me, Mr. Manuraj, has authored a book on temple entry being published by Penguins. And my lord, hopefully it will be available before the decision comes. So I would just, I would request that these books, including Mukherjee's book, should be made available to this bench. Because rather than taking it from me, what is religion and what is not religion, or from Mr. Gopal Subramaniam, I know he's an expert on the subject. You can ask him. When I want clarity on what is religion, I go to him.
This typeset contains the lectures of Bhogatji.
These books must be available to you before taking a decision. So let me say why. Let me give you the argument why. Because you are dealing with pre-constitutional laws and post-constitutional laws in this case. That's the first reason why all these books must be available. You are also dealing with judgments of the Privy Council. Let us not forget it was the Privy Council which held that an idol has a juristic personality. Where did it come from? From the Privy Council. So you're dealing with Privy Council law also. And you're dealing with the Constitution. Finally, these are the three issues you're dealing with. So the question is, what is the domain of the law that you're dealing with? The domain of the law that you're dealing with is the law relating to charitable and religious endowments. There's a branch of law known as the law dealing with charitable and religious endowments. And these laws generally cover both charity and religion. That answers the question of corporate body and incorporation. Because these institutions are incorporated either as trusts, whether the trust has a dual ownership between beneficiaries and the trustees, or whether, as Gopal Subramaniam said, they don't have that dual ownership, it's still the law of trust.
it can also be a debatter
Yes.
to the treaty,
What is debitor property? Property which is dedicated to an idol.
to the deity.
Yes, to the deity.
Even without a trust,
Yes.
the debatter will have
Yes.
dependent juristic entity.
Yes, it has.
That is what Mr. Subramaniam argued.
Yes, I agree. I agree with that. It does have juristic personality, thanks to the judgment of the Privy Council. What is the sequitur of that? The sequitur, now if that juristic entity has to act in the material world, what have the courts been doing? They've been framing a scheme under 92 of the Civil Procedure Code. Why is 92 there? 92 is there to give a corporate existence to a religious institution, which it may not have. What is challenged in Ratilal? The Bombay Trust Act. A religious institution was incorporated under a trust. So that corporate entity has to exist somewhere. So what is wrong with the three-pronged test which the court has evolved? It's the corporate entity which holds the land, unless, as I was told, that the dedication is to the idol. So the ownership then becomes, it's a separate species of property, which is dedicated to the idol. and which then can't go back for any other rule. Then all those questions will arise, whether Cyprus doctrine arises or
It's not,
rule against perpetuity doesn't apply.
it's not really been seriously contested on this point.
Yes,
What is being contested when an expansive definition of denomination is given is that we should not restrict it only to a doctrinaire approach, but matters of religion must be seen in the form of professing and practicing
yes,
religion
yes,
as the forms of worship.
yes,
And if a particular denomination or its section
yes,
has a unique form of worship or a practice,
yes.
that would also stand protected in respect of that temple or that religion institution which is established or managed.
If it survives constitutional scrutiny, yes.
Level at which the review petitioners would urge us to read the word denomination or its section, not at the macro level of a big philosophical schism.
Yes,
There is a big philosophical schism and a breach in religion.
yes,
Like if you see why Jainism, Buddhism has been always clubbed with Hinduism,
yes,
is because they are all reformist expressions of the primary Vedantic philosophies in Upanishad. So it is not where they would like us to hold the definition of denomination, as has been done in Sheshmal and series of decisions thereafter. They would like us that it is also at the management micro level of how the prayers are offered, in what manner the prayers are offered,
yes.
and in particular cases, whether certain groups of persons will be permitted to offer prayers or not. So there, the denomination, I would rather say the devolution or the more my granular level of denominational interpretation has been proposed.
Yes, my lord. Let me assume for a moment that is correct. Let us, for the sake of argument, agree with that. But the point is, no claim is being made either in a denomination or a non-denominational institution. Both. In both, you can't interfere with the rituals. In both of them. It is not as if
Debatable. That's debatable.
it's a fact, my lord. I can't enter a temple and say this is how you have to perform the rituals
Unless you
as my ladyship.
rights, until and unless you claim 26 rights, the subordination of 25 rights with other provisions of the Constitution
So they can claim it under both. They can claim multiple rights.
for individual claimants
Yes.
freedom to profess their religion and conscience is always eclipsed by the denominational
It's the other way around. My lord, that is the
religious
dispute.
institution.
That is what you have to decide. It's the other way around. The denominational right is eclipsed by the individual right. That is my case.
What you will.
Yes, yes. It exists for whom? For me. But I want to make this clear. I'm not claiming a right to interfere with rituals, whether in denominational temples or non-denominational temples. Let us be clear about that. Supposing it's not a denomination and I enter a temple, can I go there and say you perform this way or that way or a mosque? I can't do it. It is not a claim. And the way the law has evolved over 2 centuries is on the question of temple entry. That's the evolution of the law. So the question is whether you can keep anybody out for any reason whatsoever.